Hi, this is Kip from Malik Malik. I'm going to be talking about a mandamus case, 10th District case, Marion Smith versus the IC. Um, and this is kind of, before I jump into the details of this case, one thing, and I've mentioned it before, one thing you really have to adopt this mindset with your workers' comp claim is your goal always has to be returning back to work. Um, and you have to be communicating that to your doctors, to your attorney, to the industrial commission, to the independent medical evaluator, to the BWC claim service specialist when you talk to them on the phone. You want to adopt that mindset. You want that to be your goal, and you want to be communicating that goal to everybody. You never, ever, ever want to have the goal of I'm retiring, um, you know, from my work, and I'm retiring forever, and I just so happen to have a workers' comp claim. I'm going to milk this. If you kind of express that concept or idea, and you infer that concept or idea, you're really gonna short. You're gonna cut the heels from your case. You're gonna limit your entitlement to certain types of temporary total, other type of benefits. You're gonna set yourself up to have some problems. And that kind of came to light. And these inference to this retirement issue can pop up anywhere. That's the problem with this. So we have this case again, Marion Smith versus the IC, and what ended up happening in this situation was, and you'll learn this injured worker has got some significant, fairly serious physical conditions, and what ended up happening is he's lifting a patient in bed, August 8th, 2013, files a claim. He gets injured, obviously. Files a claim. His claim is allowed for a number of conditions, including right shoulder tears and neck conditions. Um, so he had been working as a physical therapy director for this hospital from 1973. So he started working in 1973, and then he retired in early 2014. So if you're keeping track of dates, the date of injury is August 8th of 2013, and he retires from this job early 2014, and it's classified or qualified as a Social Security retirement. So it's not SSD, not Social Security disability, but Social Security retirement. Um, and it may be that it just this is what I think happened. He had this work injury, and then it was kind of the time where he could have taken Social Security retirement, and so he's like, I'm kind of injured. I'm going to take Social Security retirement. And I'm and maybe that's the case. Maybe it's completely coincidental, but I think the timing, the fact that it happened in August 2013, and then he's retiring from this job early 2014, I'm assuming there's some kind of connection to the work injury there. But nevertheless, and then he continued working on I guess, a light duty kind of capacity, part time capacity for this Dannon physical therapy. And again, this is a job that he had from 1973 to February 2016, and then he was doing more additional physical therapy for this, um, on again a part-time basis, called Redenbaugh Rehab from February 2016 to November 2016. So that's the last time he worked anywhere, was November 2016. At some point, and this isn't really part of this case, but it's alluded to in the facts. At some point, he filed for permanent total disability. Obviously, this isn't permanent total disability mandamus, so it wasn't granted. The IME found that he was not permanently totally disabled, and his restrictions didn't prevent him from all forms of remunerative employment. Jump forward, January 25th, 2021, he undergoes surgery authorized through the claim. So this is surgery requested through the claim. It's authorized through the claim. It's directed at his allowed neck conditions. So if you're having surgery at your neck, that implies that you have discs allowed, and he requests comp starting July 13th, 2020. So I assume there was some condition that was added to the claim at that date, and then that's kind of the basis that they request comp, because it would be you would either request it that date, or you would have requested the data that you had surgery, and you want to capture the most comp, so you go with the July 13th, 2020. So DHO, SHO, they grant comp, so that's good for the guy. So based upon his testimony that he attempted to work for the employer, then later on a part-time basis a physical therapist, but he could not continue to do so because of pain limitations from his neck. And I think that's where whole thing should stop. And like, we're golden. But the employer filed for a request for a reconsideration by the full commission. So that means you're basically saying, hey, I want the full commission, 3 commissioners, to hear my situation. It's a unique situation. There's got to be something unique about it. I'm not really seeing anything unique about this. I'm not really sure why they took up this particular issue, but the employer's attorney must have written some compelling, request for reconsideration memo or motion. And so what the commission ended up doing is they said, well, the issue is, do they have jurisdiction to revisit this issue? And they said they did have jurisdiction because there was a mistake of fact or law, and the mistake in this situation was the reason why he was not working was for reasons unrelated to the work injury. Again, we're looking at that 412356F thing, and in this case, they said there were reasons. The reason why he wasn't working was for reasons unrelated to the work injury, and primarily because his physician of record, his BWC doctor, had listed in his Medco 14, maybe in 2016 or thereabouts, that he had work restrictions of retired, and then at some point, and I don't know if it was at the DHO, but it was indicated that his retirement in 2014 from his longtime hospital gig it was not a disability retirement, but it was a retirement, basically Social Security retirement. And so the mandamus found that he was suffering the wage loss or for reasons unrelated to the conditions allowed in his claim, and therefore he's not entitled to comp. So that's kind of their position. And so, yeah, so they found that was the case, and they denied him comp on that basis. And it's funny because it's not really funny. I mean, none of these things are funny, but it's interesting in that if you look at these AutoZone cases, and I don't know what the claimant's attorney argued necessarily, or if they argued this point assiduously, but I mean, if we're going by AutoZone, if he had physical conditions allowed, it wouldn't really matter. In my interpretation of AutoZone, it wouldn't matter if he had indicated at some point in the past that he had retired. The fact of the matter is, the reason why he wasn't working at that time was, particularly when he had the surgery in January 25th, 2021, was because of the surgery directed at the allowed neck condition as claimed. And therefore, if we're going with that 412356F AutoZone application, we only have to look at that first sentence. Is the injured worker suffering a wage loss for reasons directly related to the impairments in the allowed claim? And the answer would be yes, and that's where we stop, and he should be entitled to comp as long as he's otherwise qualified to receive temporary total disability. So that didn't happen here, and they did find, basically, again, he kind of sunk his request for comp was kind of 86 because he had indicated to somebody he'd retired, and then his doctor specifically put in his restrictions retired restrictions, work restrictions of retired, and I want to say that he testified to being retired, and I'm trying to look through my notes. Yeah, but bottom line is, again, if you take away anything from this, you cannot have this mindset of I've got a work injury and I'm now retired. Now, you could get a work injury and be found permanently and totally disabled, but even to file permanent totally disability, you have to exhaust unless you're medically PTD, you have to, and even then you might still have to at least try to do vocational rehabilitation, then that fails, or you have to try to re-enter the workforce, and that fails after you're found MMI and your comp's cut off. Because if you don't, they're gonna bring that up, and it's gonna burn you. So, bottom line is, you don't want to be communicating that you're retiring, and you don't want to have that mindset that you're retiring. You always want to have the mindset, and this is a positive thing, anyways. Hey, I want to return back to work, and that's the goal. Ultimately, that's the goal of workers' comp, is to keep people working, and so you have to embrace that idea of, I'm going to try to work, assuming you physically can. Some people, their work injuries are so serious that they're not going to be able to work again, and hence that's why there's such a thing as permanent and total disability. Unfortunately, for some folks, that's what ends up happening with these injuries. Regardless, as I say at the end of all these things, workers' comp is a complicated beast, and you consult with your friends, families, coworkers, doctors, whomever, and ask who they use or who they recommend as a workers' comp attorney, and use that person. If you need to talk to multiple workers' comp attorneys, do so. Don't do this stuff alone, because again, workers' comp it's a complicated beast. And if you're noticing in these videos, why am I sitting down? I'm actually in the basement of my office, and what you see behind you, it looks like I'm in a warehouse, but these are shelving, and all these shelves, this is in the time before, paperless offices. These shelves would have been full of files and whatnot, and we've subsequently recycled these files, and these things are digitally stored. So I'm in my scary basement, trying to find someplace quiet to do these videos. So that's why I am hiding in a basement. That's why you see a bunch of shelving behind me. So this is my new home. I'm a basement dweller now. Anyways, thanks for watching this video. This is Kip from Alec and Alec. Stay safe, and I will see you next time.